PSM ni bersama dengan kumpulan-kumpulan yang lain lah, with other organisation seperti MTUC, seperti the Bar Council, Jerit, Suaram, Women Organisation, WAO, Empower, Sahabat Wanita, Parti Rakyat Malaysia, PRM. Kita oppose amendment. Bagi PSM ini, we consider this amendment as Draconian, satu pindaan yang kejam. Dan MTUC mengatakan ini adalah pindaan yang paling teruk dalam 40 tahun, the worst amendment in 40 years. Tetapi buat masanya, hanya akta, sebahagian akta pekerja 1955, di mana first reading is already done. So the second reading is supposed to come up in this coming parliament session. We hope that the minister will not table the second reading. Okay. Yang kedua, ada lagi beberapa proposal pindahan sekali lagi dalam akta pekerja, akta perhubungan perusahaan dan juga akta kesatuan kerja. You know, there are other amendments which are planned, haven't gone for first reading. We also are protesting, and we also hope that these amendments will not be put in parliament in this coming sitting. Instead, all this while, workers group, trade unions, kesatuan sekerja dan kumpulan-kumpulan masyarakat, they have been asking for other laws. For example, the Minimum Wage Act. They have been asking for retrenchment fund, akta pembuangan pekerja, so that when a worker is sacked, there is a fund to be given. They have been asking for automatic registration of trade union. Okay, tetapi the government have not passed any of this law. Though all these laws, the groups have been asking for more than 10 years. But what they are doing now, they are making laws which are favorable to the big corporate sector, to the companies. And baru-baru ini kita tahu kerajaan pula mengatakan akan membuat amendment, akan mengubah akta gaji minima. PSM feels this will not happen because gaji minima is opposed by the Employers Federation. So far, whatever the Employers Federation have opposed, they have not implemented. So they have been delaying this for many years. You know, they were telling at one point they'll give minimum wage for security workers. Then they were talking about minimum wage for maids. They have not done any of it. Now they are talking about conducting more studies. So they are just buying time. We are very convinced that they are not going to implement the Minimum Wage Act. If at all, that is the first act they should implement. A study by the Human Resource Ministry, this is the study done by the ministry itself, revealed that 34% or about 1.3 million workers earn less than 700 a month, when the poverty line was 720. 1.3 million workers earn less than 700 a month. The minister also cited the World Bank study, which discovered that the wage trend in Malaysia has only recorded 2.6% growth annually during the last 10 years. We know how much inflation have gone up. So we believe that this amendment at this time is going to create a lot of hardship to the workers in this country. The biggest amendment which they've already tabled, this is the most dangerous amendment, is where they've changed the definition. Mereka telah tukar definisi apa itu majikan, employer. This is the most draconian and the most cruel part of this act. The proposed amendment recognizes a new category of contractor, that is the contractor of labor, whose job is merely to supply labor. Contractor is also part and parcel of the work. Last time, today, if this is passed, then workers will be dealing with contractors, no more their employers. So, hubungan pekerja dengan majikan sudah tidak ada. You hanya boleh mengadu kepada kontraktor.
Now, as it stands now, an employee who feels he has been unlawfully terminated has a recourse at the industrial court. I just give you a little bit of background. When an employee is terminated, for example, and if he feels that his termination is unlawful, he can lodge a complaint, and then the matter lands at the industrial court. And at the industrial court chairman will determine whether the employee has been terminated with just cause. That means the employer must prove that there was some wrongdoing or some misconduct that the employee has committed before to justify the termination. Now, what's happened is there are several proposals being considered to restrict access to justice for certain categories of workers, namely those with 1-year fixed-term contract, which also includes probationers. Those who earn $10,000 and above are denied access to the industrial court. Those who are already retired, those who have accepted retrenchment benefits, mutual separation agreements, those categories of people are also excluded from seeking remedy at the industrial court. Now, as Arul has said, security of tenure is very much the norm in Malaysia in the light of our Industrial Relations Act. And this too is also provided for in the Federal Constitution. There is also Article 8, which says equality before the law. Everyone is equal before the law. If everybody is equal before the law, why do you now suddenly identify certain categories of people to be excluded? Now, the Home Minister has, the Human Resource Minister has reviewed the position, and all these things is being done in the name of FDIs. Foreign investors are apparently very concerned with our laws because they want to hire and fire, but they can't, because our law says you must show just cause. When you go to the court must be satisfied that you have a justifiable reason. Now, these categories of people are being excluded. When you exclude these categories of people at the industrial court, what remedy do they have? At best, they can go to the civil courts. And in the civil court cannot reinstate the worker. The civil court has got no power to reinstate the worker. Your remedy in the civil court is somewhat limited by the employment contract that you sign. For example, if the employment contract says either party can give 3 months notice, your remedy in the civil court would be substantially confined to a very small figure. Whereas if you go to the industrial court, the remedy at the industrial court is reinstatement. So if you have been unlawfully or just unjustified, your termination is unjustified, you have been victimized, the industrial court can offer you a remedy. Reinstate the worker, put him back in the position that he was before he was terminated. So these proposals certainly is very drastic, very radical proposals. The Bar Council is certainly opposed to the proposals that have been suggested by the Human Resource Ministry. The other objection that the Bar Council takes is the fact that the Minister is considering allowing consultants to represent employees at the industrial court.